So imagine winning over $100 million in state court for wage theft.
Right.
And then, a federal judge just steps in and completely erases the entire victory.
Yeah, it is wild. It really is.
Right. Well, today we are doing a deep dive into a California Judicial Council analysis of Magadia v. Wal-Mart. And our mission for you listening is to figure out how a trapdoor like that even opens up in the first place.
Because it really exposes this hidden maze in the justice system, It highlights the massive tension between these incredibly complex labor laws and the everyday self-represented worker who is just trying to navigate them.
Exactly. I mean, it is the perfect case study of what happens when a state law's intent just completely collides with the strict procedural reality of a federal courtroom.
Right. So Roderick Magadia was a former Wal-Mart associate, and he won that massive payout for wage and meal break violations.
But the federal court just threw it out.
Yeah. And they did it based on the standing trial.
Yeah. Wait, I am a bit confused. If California state law says the lawsuit is legal, how does a federal court just step in and say no? Aren't state labor laws governed by the state?
Well, they are, but large class actions often get removed to federal court under jurisdictional rules. And federal courts demand Article 3 standing, which means an injury in fact.
Okay, so a specific personal injury.
Exactly. Under California's Private Attorneys General Act, or PAGA, workers can essentially sue their employer on behalf of all their colleagues, right? Even if they didn't personally suffer that specific violation.
Wow.
Yeah, it is a broad representative model. But federal courts say, well, if you weren't personally injured by this specific practice, you have no standing here.
Here's where it gets really interesting. It is like you are the neighborhood watch captain, right? And the state says, great, report any broken window you see on the block.
Right, yeah.
But then the federal court steps in and says, wait a minute, you can't report a broken window unless it is specifically your window.
What's fascinating here is the reason why the federal court draws that line. They basically ruled that PAGA isn't a true qui tam action.
A qui tam action?
Yeah.
Like whistleblowing.
Yeah, exactly. Like blowing the whistle on defense contractor fraud. In those traditional cases, a private citizen sues on behalf of the government, but the government keeps strict procedural control over the lawsuit.
Oh, I see. So under PAGA, they don't have that control.
Right. Under PAGA, if the state declines to investigate a labor claim, it has no authority to intervene or manage the litigation later. Because the government lacks that control, the federal court just shut the door on those purely representative claims.
Okay, let's unpack this. If federal courts now demand personal proof of injury, how is a self-represented worker supposed to even spot their own injury?
It is incredibly difficult.
Right. Like, how are you supposed to audit your own pay without hiring a forensic accountant? Especially when the wage statement, hides the actual math behind a retroactive lump sum.
And that exact question is at the heart of the MyShare bonus issue in this case.
Right.
Walmart gave out these quarterly bonuses. Okay. And under the law, those bonuses have to be factored into the regular rate of pay for calculating overtime. But since the bonus is quarterly, the company has to do a retroactive adjustment or a true-up.
A true-up for any overtime worked during those previous 3 months, which means doing complex fractional math on previous pay periods.
Precisely. But here is the kicker. The court ruled employers actually do not have to itemize the specific hourly rates and hours worked on those retroactive adjustments on the pay stub.
Wait, really? So it just shows up as a lump sum?
Just a lump sum. Add to that, the 2024 PAGA reforms codified this strict standing requirement into state law too. So now you must personally experience the violation to sue.
Oh, wow. So they just codified it entirely.
Yeah. And they also capped employer penalties at 15% if the company takes, reasonable steps to fix errors early on.
So you have this system where the burden of complex math and strict legal standing just falls completely on the worker.
And the result is courts are just overflowing with confused, unrepresented litigants who can't decipher their own pay stubs, let alone federal standing doctrines.
So what does this all mean? It sounds like technology is essentially being used as a mandatory translator for a system speaking a legal language regular people just don't understand.
That is exactly the Judicial Council's counter-strategy here. Since equal access to a physical courtroom is harder than ever for these unrepresented workers, the state is relying heavily on technology to automate that procedural load. We see this with digital tools like My Citation.
Oh, right, the tool for traffic fines.
Exactly. It helps litigants reduce traffic fines, and it has already saved people about $110 million.
That is massive. Over 328,000 litigants, right?
Yep, it is huge. But it is part of a broader, aggressive push. They are expanding permanent remote proceedings and launching a new AI task force to handle the sheer volume of people navigating this maze manually.
It is a constant tug-of-war, isn't it? Like between a business's operational ease and a worker's right to transparency.
Absolutely. Procedural fairness is hanging right in the balance, and the state is basically trying to code its way out of the bottleneck.
Which leaves you with a critical question to consider. As the justice system becomes increasingly reliant on AI tools and digital portals to guide the self-represented through these invisible math problems.
Right. Where does it lead?
Will it truly democratize the law? Or will it just create a highly efficient, automated barrier to the physical courtroom? Something to mull over the next time you look at the fine print on a pay stub.